Hello my dear friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will discuss about the Supreme Court verdict on Rafale deal documents and how this impacts the freedom of press. Now if we look into the current affair, the Supreme Court rejected the central government's argument that the Rafale deal documents published in the Hindu and the Wire were privileged. So the central government had claimed that certain documents that were published in two newspapers, that is the Hindu and the Wire, were privileged. So the Supreme Court rejected this argument of the central government, saying that the documents published in the newspapers cannot be considered as privileged documents. So in this lecture we will see why it is called privileged documents and what is the rationale behind the Supreme Court in making the verdict, and also what is the significance of the verdict. But before we begin, this is our channel StudyIQ and we are providing pen drive courses for various competitive examinations including SSC and bank courses, UPSC optionals, SSC JE courses, teaching examination, railway examination, defense examination, RBI grade B, NABARD grade A, UGC NET, UPSC Civil Services Examination, CLAT exams for various state PSCs and also for various professional courses. You can visit our website www.studyiq.com for more details, or you can call to any of these numbers for more information. Now let us understand the case in brief. So, in the month of December 2018, the Supreme Court had given its verdict on the Rafale deal or the Rafale aircraft acquisition deal. So, the verdict was already given by the Supreme Court in 2018 December. And in the Supreme Court verdict, it was in line with the central government. The Supreme Court held that there was no substance to the allegation of commercial favoritism in the deal. So, the verdict was in favor of the central government, saying that there is no instances found of commercial favoritism in the Rafale deal. And soon after the verdict of the Supreme Court, after a few days, certain documents revealing the discrepancies in the Rafale deal had been published by two newspapers, the Hindu and the Wire. And after these documents were published in these newspapers, the petitioners of the case again sought a review of the Supreme Court of the December 2018 judgment. So after the documents were published in the newspapers, the petitioners of the case had asked the Supreme Court for a review of its earlier verdict. But the central government argued or maintained the stance that the privileged documents were procured by the petitioners in an illegal way. So the central government said that these documents are privileged. It means that the general public should not or does not have access to these documents because these are privileged and these documents are the sole authority of the government. And in this regard, the center said that the publishers of this document had procured this document by illegal means. And the central government also argued that the documents had been removed from the Ministry of Defense without authorization. And representing the government, the Attorney General or the AG raised three specific questions. The first question, relying on the documents, was violative of the Official Secrets Act. So the Official Secrets Act allows the government to maintain certain documents under the Official Secrets Act without making it available in the public domain. So the AG said that relying on the documents was violative of the Official Secrets Act. And secondly, the documents could not be assessed under the Right to Information Act. So it cannot be assessed by the court under the RTI. And third argument was that the government was entitled to privilege under the Evidence Act. So, the central government raised objections that the documents on which it claimed privilege cannot be relied upon to re-examine the verdict. So, the petitioners had given a review petition in the Supreme Court in order to review its own verdict, the Supreme Court's own verdict on Rafale deal, based on the documents published by Hindu and the Wire. So, the argument of the central government was that considering all these, Official Secrets Act, RTI and the Evidence Act, these documents published by the two newspapers are unauthorized and therefore the Supreme Court cannot or should not depend on these documents to review the verdict. Then later on what happened, the recent verdict of the Supreme Court has dismissed this preliminary objections raised by the government. So it means that the Supreme Court is depending on these documents in order to review the verdict given by the Supreme Court itself. So the preliminary objections raised by the central government has been dismissed by the Supreme Court. Supreme Court is not considering the preliminary objections of the central government. Now we will understand what is the court's rationale in this regard. In the very beginning of this case, the Supreme Court said that the issue before the court is not regarding the freedom of press, but the petitioners had relied upon certain articles which were published on various media platforms. So, following this, the Supreme Court acknowledged the case to be an appropriate occasion in order to recall the views of the Supreme Court on the critical issue of freedom of press. So now, Supreme Court is considering this as a appropriate situation or an occasion to recall or to review its opinions and views on the freedom of press. And the Supreme Court also observed that the right of such publication by the media is in consonance with the constitutional guarantee of freedom of speech under Article 19 of the Indian Constitution. So, the Supreme Court has also upheld the constitutional validity of it. In the earlier judgment also, the Supreme Court held that the freedom of press was at the foundation of all democratic organizations, and it is a structural or foundational characteristic of democracy. And also, there are no laws as such by the Parliament that specifically bars or prohibits the publication of such documents by the media. And also, if you look into the Official Secrets Act, there is no such provision under the Official Secrets Act that restrain the publication of documents marked as secret. And it is also not prohibited from being placed before a court of justice. And in this process, a judge also mentioned about 4 broad social purposes of freedom of expression or freedom of speech. Let us look what are the 4 social purposes of freedom of speech or freedom of expression. The first one is to help an individual to attain self-fulfillment. Second one, it assists in the discovery of truth. Thirdly, it strengthens the capacity of an individual in participating in decision making. So it helps in better decision making. And fourth, it provides a mechanism by which it would be possible to establish a reasonable balance between stability and social change. And Supreme Court also observed that it is not much important that how a piece of evidence is being obtained. So that is immaterial. But if the material so obtained or the evidence so obtained is relevant to the issue, then it can be considered by the court. So the source of the evidence is not much important compared to the relevance of the material or the evidence. Now, according to principles of law and justice, the court allowed the published documents to be relied upon by the petitioners. So, the Supreme Court has upheld that the petitioners can rely upon the published documents in the 2 newspapers regarding the Rafale deal case. And with this, the review petitions filed by the petitioners will be taken up by the court on merits. Now, let us understand what is the significance of this on freedom of press. So, it was the Supreme Court's unanimous verdict that these documents published in the media should be considered. So, this is a step towards rejecting the government's attempts to delegitimize investigative journalism, or it provides a boost or encouragement for investigative journalism. And secondly, the judgment will provide more clarity on several aspects of the controversial Rafale deal. And apart from the Rafale deal, this judgment of the Supreme Court in order to take up the evidences based on media publications is very important because it rejuvenates the right of free press and underscores the principles that it is the public interest that would decide the worth of such rights. So, this is an encouragement to the right of free press. So, in this aspect, apart or above the Rafale deal, this judgment of the Supreme Court is very significant. For more video updates of my lectures, you can follow my Facebook page, and for any suggestions and queries, you can write to me at joycey.studyiq@gmail.com. Thank you.